So welcome everybody. I'd like to give a little introduction into data protection. I mean, there's a lot of discussion right now going on about everything about the new General Data Protection Regulation, and I wanted to give you a bit of a background what it's all about. So who's afraid? Well, the GDPR is a European regulation on data protection. That means it will be directly applicable as law in the different countries, different to a directive, and it will become effective on the 25th of May. So what's special about it is it's got a lot of scope for opening clauses for different national specifications, which brings it rather close again to a directive. And what's important is it's got considerable consequences for the way we are processing personal data. So there are specific provisions for research in the GDPR, and that's rather important for us because first it does indicate in the preamble in recital 33 that a broad consent for research is rather possible and encouraged and understood, because it is indeed not possible always in the beginning to later on know what it's all going to be about. And there are derogations from data subjects' rights for research. There's secondary use of data possible for research, and it's seen as compatible with the original purpose. And it's also acknowledged that a longer storage duration is possible. So overall, there is an acknowledgement of research as an important good in the GDPR. So basically, why is everyone afraid? And why is the GDPR actually different to the previous directive? Well, in the first place, suddenly we're responsible for the data processing we're doing. We're accountable, and we need to be able to give proof of what we're doing. There will be audits to check if we really do what we claim that we do. And last not least, there are considerable fines in case we don't. And these fines can go up to 20 million euros. So it's not small cash money we're talking about. Now, to give an introduction to the GDPR, maybe it's good to have some first definitions and expressions made clear. So when we talk, for example, about processing personal data, processing means really any operation on the data, not just the analysis. It's the collection, it's the recording, it is of course the analysis, but also simply the storage. If you store personal data, it means you're processing the data and you're responsible and accountable for what you're doing. The leading principles in the GDPR is that the processing must always comply with lawfulness, fairness, and transparency. Now, what's personal data? And again, we need to be careful how we define that, because personal data is any information that's related to an identified or identifiable natural person. And that means it's not just the data that identifies a person or data that's somehow, impacting a person if you know about it. It's really any data, that information that can be related to this natural person. And when we talk of pseudo-anonymized data, that's data then where the directly identifying data has been removed and replaced by an attribute that can be linked with additional information later on back to the person. And it's very important to know that in the GDPR it's being specified that pseudo-anonymized data is personal data. And that means any pseudo-anonymized data we've got in storage that we're processing needs to be reported about and accounted for. Now, if we talk about anonymized data, well, anonymized data is indeed data that is not considered by the GDPR and is outside the GDPR. But in this case, the data really does not relate to an identified or identifiable natural person. And it means here, or it's kind of being defined, that you need to consider the means reasonably likely to be used to single out or re-identify a person just from the data that you've got. But it can also mean it shouldn't be, linked with other data that's outside available to find back to the person. It should definitely be impossible to find the person behind this data, at least considering the kind of the costs and amount of time on the technology that's available to be able to link back. But it's important to know that this is considered at the time of the processing, and we'll come back to that later. Then what's being defined as special categories of personal data, and used to be called sensitive data in the past, apart from other data that's also affected. For us, most important special categories of data are racial or ethnic origin, genetic data, and data concerning health. And it's important to know that the processing of this data is prohibited. Well, prohibited unless. And you can process it either if an explicit consent is given, or if it's foreseen in the national implementation of the member states that it's necessary for the scientific research on this kind of, the purposes of the research should be proportionate to the fact that very sensitive data is being processed. There's another important element that in the same article of these special categories of data, it's that the member states can, in particular for processing health and genetic data, have special provisions, limitations, special conditions. And I'm afraid there are quite a few member states who make use of that. Then we go on to the who is who. And it's important to know and make a difference between a controller and a processor of personal data. So the controller is basically the one who determines the purposes and the means of the processing, according to the GDPR, while the processor is only the one who processes the data on behalf of the controller. And to really tell the difference between the two, the leading questions that were provided by the Working Party 29, which is the committee of all the different national data protection authorities, is that you say, well, why is this processing taking place? Who has initiated it? And in terms of research, it means basically who has come up with the research question and the ideas of this research project. If you decide to do a genetics analysis and just get a partner in to do this analysis, that partner may well be a processor. But if you sit together on the table and you say, let's better understand, the background of neurodegeneration, and your partner says, well, I can do some great genetics research and we could find out this and that for that, then you become joint controller for this project. Then going on to the who is the supervisory authority, or also called data protection authority. And the data protection authority is responsible for the monitoring of the application of data protection law in the different countries. And in the past, under the directive, it was that you as a researcher had to notify them and often ask for authorization to do the processing. Now that's in principle a thing of the past. So under the GDPR, the data protection authorities become a more policing role. So they investigate how you follow the GDPR, they do audits, they can give a ban on processing, and they're also the one to give you these so-called administrative fines, where we already mentioned that these can be considerable. Now, it can of course be that in the different national law implementations that there's still authorization and notification necessary, but that's not the basis a priori in the GDPR. Now let's move on to the rights of the data subjects. There are several groups of rights which are just important to know, and they're actually not so difficult to the rights of the data subjects in the past under the directive. And one group of rights is really the right to information, that the data subject knows what's being done with his or her data. And these are summarized in the Article 13, which applies to when data is being collected directly from the data subject. There's another one, which is Article 14, which applies if the data is not collected directly from the data subject. That means from other sources, for example, or where there's not really directly data collected from the data subject. And the data subject has also the right of access and can always ask, what do you have stored in me, and what are you doing with it, with whom have you shared it at any time during the processing of the data. Another group of rights is the right to inhibit the processing. And that's covered by the following articles. There's in Article 17, the right to erasure, also often quoted as the right to be forgotten. There's a right to the restriction of processing, so not complete erasure, but limit the processing. There's a right that you as a controller notify everyone you've shared the data with about any rectification or erasure of the data. And there's also a right to object to the processing of the data, which is important when the processing is not based on consent. Then there's some other rights which go on top, on which is the Article 16 with the right to the rectification of the data if it's wrong, and Article 20, and that is new, which is the right to data portability, which means the data subject can ask you to make the data available to a different data processor or data controller. So, question is, how do we escape all these rights? Because they can make life of a researcher very difficult. There are derogations for research, in particular for research and archiving and statistics foreseen in the GDPR. Well, in the first place, for the Article 13, the information collected directly from the data subject or the portability, there is no immediate derogation foreseen in the GDPR. So no escaping there in the first place. For Article 14, when the data is not collected directly from the data subject, it's possible to have a derogation if the provision of such information is either impossible or it would involve a disproportionate effort because you're not having a direct contact with the data subject. Then there's a number of articles, which is the right to access, to rectification, to notification, to objection, where it's up to the different member states if they do a derogation for research, yes or no. And then there's another hardwired derogation, which is the right to be forgotten, and there it's when this right makes research either impossible or seriously impairs the achievement of the objectives, then it's also possible to get a derogation of this right. So let's move on and see what are the challenges that we have to face. As mentioned before, anonymisation is a great way out, and it's actually been encouraged in the GDPR that we anonymize wherever it's compatible with the purpose of the processing our data. But the problem is that the status of anonymization is very difficult to establish. So you start with a person fully identified, and I think it's very common everywhere, so you just take away the direct identifiers. But this does not mean that this person is anonymized, because there might be information out where if you link the data, you immediately can go back to the data subject, and you'll have to find out that the person was not anonymized after all. So the next step is that you just take away further data to really reduce the chance of linkability. But depending on what you remove, there's a way to kind of extrapolate the data you've left out, and that's being called inference. So you can, through inference, still go back to the previous level where you could identify the person. So the step is that you really start to obscure the data, to not allow such inference, to really not allow to go back to some other data where you can link. That actually often includes that the data becomes worthless because there's so much missing or there's so much change and obscure that it's difficult to find what you were actually looking for when you do not really know in health research what the clues are. So, but even if you've done that, if you have a cohort of people and then you look at all these people and you find out there's one person that sticks out, and that you'll be able just by that feature to single out that person and bring it back to the actual person behind. So basically, it's a very difficult aspect and status to achieve. And what's more important, it changes over time. with the progressing technologies, with the information society, more and more information becoming available, this is a bit of a time bomb, and you never know when your status will be blown or not. So we're in the lurch. We have sensitive data, and what we do, it's potentially impossible to anonymize this data. So the GDPR applies in fully, and there are different national provisions that make it even more complicated to comply with what we're allowed and not allowed to do with the data. Well, the good news are you're not alone. The GDPR foresees a data protection officer, and the role of this data protection officer, which must be designated, I think, in all cases that apply to us, which is when you're a public body, when you're doing a massive processing of sensitive data, as we do in health research, then you need to have a data protection officer, and this person monitors your compliance with the GDPR. And they're the contact to the supervisory authorities for you, and kind of build this bridge. And most important, they tell you about your obligations, and they help you to become compliant, and they also help you to do a data protection impact assessment on the processing of your data. Data protection impact assessment. This is a new feature of the GDPR, and we'll come to that, because data protection impact assessment goes back to the idea of responsibility and accountability. And what does that imply? Well, in the first place, you are responsible for the integrity and the confidentiality of the data. And that means if that is broken and you have a data breach, you're obliged to notify this data breach to the supervisory authorities within 72 hours. It's something very much to prepare for, and be ready if something happens, that you have everything under control on how you can do that, and also comply immediately with that breach and stop it. Now, the data protection impact assessment is simply the assessment of what are the risks that may occur. On the other hand, what are the mitigations that you have to counteract these risks and minimize the risk? As a risk is hardly ever zero, you need to see just what is a risk that remains. And if you find out that the remaining risk is still rather high, then you're obliged to do a prior consultation of the supervisory authorities, which is mandatory, and need to figure out with them, is it acceptable, yes or no? Do we have to implement additional safeguards and measures, or is it not possible to pursue the path we are wanting to pursue? And most of all, again, it's accountability. So what you need to do is you need to document the kind of data protection impact assessments, the measures you have taken, on why you've come to the conclusion that the remaining risk is low enough to pursue the processing. So, now, in the past, it often happened that a lot of data was flying around, no one knew anymore what was there, principal investigators had left, data is still lying around, no one knows what's there. It's something that may have happened not in your research institution, but maybe in others, and it's definitely something that mustn't happen in the future. So what do we need? Well, what we need is data provenance. And that data provenance, we want to know which data do we have? What am I allowed to do with the data? How long can I keep this data? Where is it? Where is the data actually located? And how many copies do I have? And who's working on it? And for which projects and which purposes? And that all needs to be covered. And once you want your data to be safe, and when you want it to be really safe, what does it mean? Well, there's something like data privacy by design and default, also newly introduced in the GDPR. And that means you are obliged to provide security for the data and sufficient safeguards. That means there needs to be an access restriction to the data. So you need to make sure there's authorized personnel accessing the data only. The data should always be pseudo-anonymized, if not fully anonymized. The data should be encrypted, if possible, and when it's at rest and in transfer. There should be an access control where you can really see who is accessing the data. That you should have data minimization, so people should only have access to that part of the data they really need for their processing, and not the full entire data set. You need to monitor the compliance of all these measures, and you need to regularly review and test if your system is still holding. There will be backups where you ensure that data doesn't get lost. You need to regularly check the data integrity, and you need to have a training of the personnel accessing the data. And last not least, you should also have confidentiality clauses in the employment contracts of the people processing the data, or in the data sharing contracts if you share the data outside. Which means share, yes. Well, you know your data is safe with all the measures you've taken inside, but can you really share them? Well, the good answer is yes, you can. But in the first place, the GDPR is positive on data exchange for research. So there's, for example, in the preamble, a sentence that it should be considered that for scientific purposes, the legitimate expectation of the society for an increase of knowledge should be taken into consideration, and that should give a positive view on data sharing for research. There's also very nicely in the preamble an encouragement that data from registries, for example, should be made available for research, because there's really new knowledge and value to be gained for society from this. But here we go again. We're responsible, we're accountable, we need to be auditable, and people will come round and audit our data sharing. And last not least, we need to be able to ensure the patient's rights, and the data subject's rights rather. So, what does it mean as the responsibility as the data controller who's originally collected the data? Well, if you look at good practice to comply with the GDPR and data sharing, ideally when you share data outside your institution, the data should be anonymized where possible, or you would want to share it under a new pseudonym, as often you will only share a subset of the data, and you will not allow people to link it back later on to other subsets of the data they may have had in another context. You want to ensure a secure data transfer, which means the data needs to be encrypted for the transfer. You need to keep track of the external data users, be it other controllers, be it processes. You need to be aware of who you have shared with, for which purpose, and for how long. You need to be able to ensure the continued data subject's rights. That means if you have shared, you need to be able to tell these people which data sets may have to be changed or deleted, even if you have assigned a new pseudonym. And last not least, it's your responsibility to ensure that all the users are compliant with the GDPR. And that means, for example, if you share the data with a data processor, there's actually hardwired in the GDPR in Article 28 that you have to have a contract with the data processors, and it's given in the GDPR which clauses should be covered at least in this contract, and that's that the processor can only process the data based on written instructions by the controller. So there's no assumption, no phone call, no nothing. It needs to be documented in writing what he is allowed to do. That there's a confidentiality obligation on all personnel who is processing the data on the side of the processor, that security measures are in place to ensure the same level of security that you have as a controller, that no sub-processor is allowed without, again, your written approval, and that the processor needs to support you as a controller in obtaining all the approvals or documentations like data protection impact assessment that you need. They need to provide all the necessary information to demonstrate compliance. And last not least, at the end of the processing services, it's important that the data is either being returned or destroyed. And this is very important for you wherever you have already data shared and will continue to share it with the data processor, you need to look into your contracts and see that you do amendments according to what is needed. Now, the situation is different when we talk about sharing with another data controller, and that can be a different situation. For example, in a collaboration, there's the situation of joint controllers, which are now introduced in the GDPR. And that means that you jointly define the project and you jointly control the data for that project. But you may also have the case of an independent project. And in an independent project, someone else may approach you for his or her own project and asks you to use the data for that. Then this institution, that person becomes the controller of your data for this project. So it's not, for the entire future of your data set. You're still the controller for the data set as such. But within that project, that institution, that principal investigator is controller. And the responsibility of this other controller is, well, it's basically the same as before. It's the same obligation that you have, the same obligation that any controller has processing personal and in particular sensitive data. Here in particular, as they're controller for the project, they're only allowed to use the data for this project. And similarly to the processor, they're obliged to destroy or return the data after the project. How does this need to be documented? Well, with the processor, it was hardwired that the contract needs to be in place. It's less hardwired and less defined for other controllers. It is mentioned for joint controllers, but it's important to determine in a transparent manner the respective responsibilities. So it needs to be clear who is taking which responsibility during the processing for this data. And when it's just between controllers, so you share the data with another controller for only his project, well, this is not mentioned, but it's strongly recommended that you have a data sharing agreement in place that explicitly defines the rights and the obligations of that other controller on your data, because that's your responsibility that you ensure that anyone who's processing your data will be compliant with the GDPR. Now, if we look at the data sharing outside the EU, the current situation, what I described, was always we share inside the EU, everyone needs to comply with the GDPR. Now, if we share data outside the EU, then the GDPR is no longer applicable to these other institutions. And that, in the first place, led to the fact that data sharing cross-border to non-EU countries is prohibited. Unless, and there's always an unless in the GDPR. So there are countries that have obtained an adequacy decision from the European Commission, and there are those countries whose data protection legislation is compatible and equivalent to the GDPR. The other option is that there are appropriate safeguards in place, and these safeguards can be: the contract is based on standard clauses which are provided by the European Commission. It's also possible to have standard clauses that were kind of introduced by a national data protection authority. But if these do not work for you, there is a possibility that you have your own contract, but this specific contract has been approved by the data protection authority as adequate for sharing data outside the EU. Other possibilities are an approved code of conduct, but that needs to go along with enforceable commitments on the other side. And last not least, there's always the possibility that you have an explicit consent of the data subject, that data can be shared outside the EU and that the data subject is aware of the risks. And if there's a really public interest recognized in the law of your own country, then it is also possible to share because of that public interest. But that needs to be wired somehow and proved in the law, so it's not so easy to achieve. So, what does that mean? How to become compliant, really, and what are the kind of tools and templates you need to have? Well, coming to the ELIXIR situation, you start with a data provider, which could be a project consortium or just a study owner who provides data, which goes into your data repository for your ELIXIR node, and that's there to be shared with external data users all over the world. So it starts that you'd like to collect data from the data provider, which can be collected in some kind of a data information sheet. But behind the data information sheet is that you collect all the relevant metadata for data protection, which means what is the data actually consented for, what can it be used for, what data types are there, how long can it be kept, are there any vulnerable subjects in there, and what are the entire use conditions under which the data can be shared. With that information, you can then set up a data sharing agreement, and that data sharing agreement should really precisely define the role and responsibilities that you either have as joint controllers of data provider and ELIXIR node, or where the ELIXIR node only acts as a processor acting on behalf of the data provider. Then again, this needs to be defined according to the rules for a processor in the data sharing agreement. There's an authentication necessary before data can be uploaded, and there ideally we build on existing accounts that are already approved, and one option could be that we use the AAI for such authentication. There needs to be a secure channel, and that means we need to have an end-to-end encryption, and it should be easy to use, because sometimes, depending on who you deal with, people on the clinical side, on the laboratory side, may not be so IT literate as the computational scientists, and that needs to be taken into account. The data ideally should be REAP pseudo-anonymized when it's being ingested into the system, and that means you really need to make sure that the pseudonym under which you store the data in your node is a non-speaking pseudonym, because it does happen sometimes that the people in the clinic choose pseudonyms which still contain the date of birth or initials of a person, and it's just safer to make sure that whatever you use as a pseudonym in your system is really a non-speaking pseudonym. And it's also the chance for you to apply your own nomenclature, where you can wire into the name where you receive the data from, what data type you're dealing with, and so on and so forth, which eases the handling. The data itself should be encrypted while at rest, and here we need to go back to what we had before. You know, everything applies, the access restriction, pseudonymization, encryption, access control, so on and so forth. That needs to be ensured when you're hosting the data. And on top of that, you'll have to have a repository with all the data protection relevant metadata that you've collected, and that's being gathered during the use. And that is basically what data is there, which data types, what projects, how long do I keep it, and everything when you share the data later on should be stored in that repository. Now, to be able to share with the user, you need to have some kind of a data access management. And that means the user needs to be able to tell you who he is, where he's coming from, what the data is needed for, what data types are needed for the purpose he wants to pursue. And that will require some kind of a consent management, because the consent management needs to match the purpose and the goals of the user with what is allowed to be done with the data. Ideally, you'll be able to do that automatically, but definitely you need to be able to match what was thought about the consent and what is to be done by the user in his project. There's a data use agreement to be put in place, and this data use agreement should specify that indeed the data is only to be used for this project, that there needs to be a restricted access by only the people authorized for this project, and that data indeed needs to be deleted at the end of the project. Then for the download, once the agreement is in place, again, authentication is needed, and again, you will need secure channels of encryption and also ensuring that the data integrity is being kept. So far, so good. It's sounds doable, but there are a few things to consider, which is GDPR. There are some weaknesses of the GDPR, which I'd briefly like to touch upon. And one of these weaknesses is indeed that the GDPR was set up with lots of opening clauses for different national provisions. Most of all here relevant is that the way public interest as a legal basis for processing needs to be defined, if applicable, by each member state. So there's not a general perception of what is public interest, or in particular what is public interest or research in the public interest. And also in Article 89, when there's the derogation from the rights of the data subjects, this is up to the different countries if they employ these, and what are the necessary safeguards that are being prescribed to do that. So yeah, these definition of the safeguards are up to the different countries to be done, and some countries are more open and more flexible in that, others really go down nitty-gritty and want to define what's in the detail. Then the processing of a special category of data for scientific research, again, is to be based on member state law, and there the different countries are free to the way how they implement it, theoretically even if they implement it, but they do all implement it, but the conditions are different, and in particular with Article 9.4 means that all the further conditions, limitations to the processing of genetic and health data, there's complete freedom for every country to have special rules under which conditions you're allowed to process health and or genetic data. So just to give you an example, because this then happened, and that means we have all kinds of different legislation in the different countries on how to process genetic and health data. So the processing of genetic data in the Netherlands is for scientific research in the first place only based on consent, with the disclaimer that unless consent is impossible or requires a disproportionate effort. And that means, again, you need to have really prove that it's impossible or a disproportionate effort, which is not an easy thing to do. While in other countries, for example Germany, Austria, Luxembourg, there is no special provision for genetic data. And if you look onto further processing or this secondary use of data, beyond the original purpose that was gathered for. Now in Italy, the further processing of personal data, so any personal data, not just sensitive data, is only with the approval of the Data Protection Authority. And the Data Protection Authority has 45 days to respond to your request. If they don't respond, this is seen as a rejection. If you consider the number of requests that data protection authorities get these days, you may anticipate that this will be difficult. And for genetic data, it's just not possible at all. No further processing of genetic data without consent, which means there needs to be consent in place. There is no further processing. And again, countries like Luxembourg, Netherlands, there is no special provision for further processing. But you need to have in mind that all these rules are subject to changes because they're being done through secondary law, and secondary laws are only slowly being adapted to the new situation of the GDPR. That will take time over the next years when health laws, research laws, biobanking laws are being adapted to the new situation, and that means we need to monitor for continuous change of such conditions. Now, being aware that there are so many national differences, we suffer a bit from the applicability of the national laws. So you start out, you're a data controller based in Sweden, and you start out to do a multi-center study, gathering data in different countries of the EU. You want to store your biospecimen, all your samples you gathered, in the biobank in Luxembourg, and you'd like to have your data hosted for sustainability in the EGA in Spain. Now, there's a researcher in Hungary who wants to get access to the data that's hosted in Spain also wants to do additional analysis of the samples now hosted in Luxembourg. And the question is, which law applies? Ah well, another weakness is that there's a lot of ambiguous phrasing, there's a lot of scope for different interpretation. Just as an example from discussions I've come across in Brussels with DG Justice, and that is that data subjects in recital 33, data subjects should be allowed to give their consent to certain areas of scientific research. Now, what are certain areas of scientific research? And DG Justice said, well, health research is not acceptable as a basis for consent. Quote. And that the purpose should not be broader than research for a certain disease. And that, of course, is impossible for modern health research. Other examples are the possibility to do further processing, which is, according to Article 5, not incompatible with the initial purpose if it's being done for scientific research. And there DG Justice says that this option is only available if the processing is based on a contract. It would not be possible to evoke on that for a consent or for public interest, which is based on national law. But there's no part in the GDPR that justifies this point of view. But still, with DG Justice having this position, it's sometimes difficult to argue with the national authorities on how to read the GDPR. And that may make our life a bit more difficult, and that means we need to work together. Anyway, we've also got moving targets, and that goes back to the anonymisation. As we mentioned before, anonymisation is defined, on the one hand, good, not as absolute, but in terms of what is possible, in terms of time required, available technologies, costs involved, but it says at the time of the processing. And that means not at the time of the anonymization of the data, but any time later on when you process the data. And that means simply even if you just store the data, it may no longer be anonymized. And that, what does that mean? Well, the consequences are, well, who's responsible to check if the data which you have is being anonymized? Is that only the original controller who anonymized the data? Or is it anyone who's downloading, for example, anonymized data from the web to work on it? Does everyone has to check before if this is really anonymized data, if it's being on the web as anonymized data? And how do we check it? Do we need to attempt to de-identify the person behind it, which is explicitly forbidden in all our contracts? And then we do not have all the sources available, in particular not the most likely sources that help us to re-identify the data and link, which is Facebook, Google, what have you. So how can we really make sure that the data is anonymized? And then again, what happens once we do find out the data is no longer anonymous? I mean, there's no erasure possible. It's been out on the web, for example. Does that mean from that day onwards we keep violating the data subject's rights? So there's a lot of open questions. But, well, don't give up. In the first place, we'd like to start a survey on the ELIXIR level, just to find out what's the situation in the different nodes. And that means, do you have any services in your node where the GDPR will have an impact? If so, do you have any measures to achieve compliance? Do you have them in place, or are you working on them? Would you like to use ELIXIR tools for these GDPR relevant services? Are there any other tools you'd like to have available centrally to achieve compliance, and that we could do from the ELIXIR central level? And then we'd like to find out, do you have already training modules in place, something we could share with each other? Are you aware of the different provisions for the national implementation in your country, where you could pool the information about this? And all this we want to bring together into a workshop on data protection, where we want to explore the already existing solutions and the joint interests We'll hold that workshop in April. It's aimed at the technical coordinators who are aware of all the tools in place or needed, and of the people who are dealing with your data protection, with your GDPR compliance. What it's about, well, we want to exchange in our experiences on the challenges we have to face. We'll pick some defined use cases where we really go through in detail what is there, what is still needed, so we can identify common needs. We can clarify open questions, or get them at least defined together. And as an expected outcome of this is that we will create a joint working group where we can further tackle the aspects, and that we define a roadmap of activities for this working group. And that working group indeed has the idea that together we can achieve more, and hopefully more easily. So we can work on joint solutions. Not everyone has to reinvent the wheel, himself. We can develop a common voice to talk, for example, to DG Justice. We can define the input for the scientific program of ELIXIR, which is currently being written, which will define the focus over the next few years on where we have an urgent need, all of us, within data protection. We can ask for new or improved tools to be provided within that program. We'll be able to give a joint feedback. There's often public consultations by this working group 29 that interprets across the different member states the GDPR. And we can give feedback on how well this matches our situation in research, because usually the data protection authorities are not very well experienced in the needs of research. There's also currently, under the leadership of the biobanking infrastructure, BBMRI, the initiative to develop a code of conduct for health research, to have special rules acknowledged then on the EU level on how to deal with health research with the special provisions and under the ambiguities of the GDPR, and we could bring in our point of view. So, time is running. We all need to get ready now, but we hope that together we'll make it. Thank you very much.